My name is David Wingate. Thank you so much for being here today. We're talking about how to protect your home and savings from nursing home costs and some other issues regarding probate, etc. And we'll be getting into that. So once again, I appreciate you being on this webinar. Sorry, I'm technical difficulties with the screen here. It's very hard, with the Zoom. So what we have a tendency to do, and we found this, that most people like this, that most people are muted. However, I will stay, afterwards if there's any discussion, comments, questions, or whatever. But if you do have a question, you can go into the what we call the chat room, and that's sort of in the middle of the screen, and you can hit the chat, and then you can basically send a message. And Kristen's on the webinar here today, and she'll be taking any of these chats, questions or comments that you have, and she'll relay them to me, and then we can discuss them. And also at the end, I'll open it up to questions or comments as well. Okay. So I'm sort of going to give you a story, and this is the story of Sam and Beth. A story of life, taking life as it comes. And life is grand at this moment in time. They're doing very well. They have a family, they have children, they're now seeing grandchildren, and they've got money, and they can go on used to be able to go on vacations. Hopefully we can go on vacations again soon and travel in this world, okay? As I say, they're financially comfortable. They've got a house, they've got a couple of cars, they're good health. They've got a small nest egg, they've got about $500,000. So, they're not flying off to Monte Carlo in their private plane, but, they're doing well. They have income and pensions as well from Social Security, etc. However, as life has it, Beth has a stroke, and basically she's taken to hospital, and she's in the hospital. She has 3 overnights in the hospital, and then she's sent to rehab. So Sam goes to visit, tries to visit, with COVID. There's some issues with COVID now, but traditionally before, Sam goes to visit her in the nursing home. And he talks to the administrator, and he has a number of questions like everybody has. When's she going to come home? Is she going to come home? And basically the nursing home are saying more likely than not, because of the stroke, she is not going to be coming home. Now, Medicare will cover the first 20 days. If you've been transferred from a hospital, usually if it's 3 overnights, you're transferred, and then you can go on Medicare. So as I say, the first 20 days is covered. However, 21 to 100 days, you're in a copay situation with the nursing home. Medicare will pay approximately 80%, and 20% is out of pocket, unless you have a supplemental insurance, Humana, United Healthcare, those type of supplemental Medicare supplemental plans. They'll cover the other 20%. However, you're not guaranteed those 100 days. As long as you're getting better and you're performing all your physical therapy, speech therapies, etc., then Medicare will cover that. However, say after 35 days, Beth decides not to do speech therapy, physical therapy, she just stops, Medicare will stop paying, and so will the supplemental insurance. And if she's still in the nursing home, now she's on private pay. When Sam meets with the administrator, he's found out that he has a problem. He does not have any legal authority to make decisions for Beth, i.e. admitting her into the nursing home, dealing with her medical issues, and also any financial issues that we'll talk about in the morning, later on this morning. And he also realizes that came as a shock to him, it's going to cost a lot of money. As we'll find out, the average cost in this sort of area is per month anywhere from $12,000 to $15,000 a month. So for most people, it's going to, most people are going to run out of money. It's going to be devastated. So to begin with, why can't Sam move into Beth into the nursing home or make decisions for her? Sam has no legal authority, as we talked about, to make financial decisions, sell joint real estate, your home, make medical decisions, review medical records. We talked about admitting Beth to the nursing home and guarantee Beth's end-of-line wishes are followed. Why is this? Because they do not have power of attorneys. And we'll talk about the power of the attorneys right at this moment. So if Beth is incompetent, I mean, she can't make decisions for herself because of the stroke, Sam then needs to go to the courthouse and go through a guardianship. And that is very expensive. It takes over $10,000. It usually takes 90 to 120 days to get the guardianship. So who's going to make decisions for Beth? You would think Sam could, but he doesn't have that legal authority. And then the issue is that you have court oversight for the rest of Beth's time here, as long as she's alive. Because if Beth needs some psychotic drugs or whatever, then you've got to go to the court and get approval by a person in a black robe to make decisions for you. And I don't know about you or me, I don't want a judge making a decision for me. I want someone that I appoint making a decision for me. So how could have this been avoided? How can we avoid guardianship? And how can we allow Sam to make decisions for Beth? Yes, you can with the right legal documents. And that the legal documents that you have are a financial power of attorney, healthcare power of attorney, and for most people, they'll call them living will or healthcare directives. Okay, because most people think, well, Beth is my wife, or Sam is my husband. I can make financial and medical decisions for them. Unfortunately, you can't. So that's why the power of attorneys, to me, are the most important documents, because we're dealing with you while you're still alive. So what is a financial power of attorney? So for me, if I'm capable of making my decisions, I make my own decisions now. However, if I said like Beth or Sam, if they got sick, then I want to appoint someone who's going to make my financial decisions for me. So for me, I have my spouse. Now, if my spouse can't do it, then we have, the kids. It can be anybody you want. It can be your brothers, sisters, best friend, or whatever. We always have at least 2 or 3 successor power of attorneys to your original power of attorney. So what can that power of attorney do? The easiest way to think about it is anything that I can do or Beth could do, then Sam or my spouse can do for me. They can open and close bank accounts. They can sell the home. They can defend me in litigation. They can actually pursue litigation. God forbid that I was hit in a car accident. They could hire one of those personal injury attorneys. The most important part of a financial power of attorney is to make gifts. So I always say, if you don't have a financial power of attorney or a medical power of attorney, you need it. However, if you do have a financial power of attorney, I want you to review it today to make sure that you have what we call a gifting clause. And the gifting clause is very important if you end up going into the nursing home, because one of the ways that we'll find out is to protect your assets. We need to have that clause in there. You can also set up trusts. And so it's very, very important, as I say, that, so if I get sick, my spouse is going to step in my shoes to make any and all financial decisions. And it's very similar to the healthcare power of attorney. Instead of dealing with financial issues, you're dealing with your health and welfare. So once again, you know, if I went to your physician and said, let me talk to you about you, the doctor should tell me no, because you haven't given me a release. So this is very important that you have that power of attorney. So you appoint someone so they can talk to doctors, physicians, home care agencies, whomever, to make medical decisions. They consent to surgery, or they withdraw, you know, and say you don't have to have surgery. You can admit or discharge from a hospital or nursing home. And part of our healthcare power of attorney is that you have what we call a HIPAA release. HIPAA is the Privacy Act. So as I said, if I went to your physician and said, let me see your medical records, the physician should tell me no, because we don't have that HIPAA release. So the healthcare power of attorney, once again, is anything I can do. If I get sick, my healthcare power of attorney can make decisions for me. Another component of our healthcare power of attorney is what we call the living will, or the advance directive, medical care directive, etc. We actually include this in our healthcare power of attorney, but you can have it independent of that as well. And this is basically an expression of your wishes regarding your end of life. So if Beth was in a vegetative state or end stage condition, she's telling Sam what she wants. Just let me go, but provide me comfort care, or, you know, regarding food and nutrition, etc. So it's very, you know, to me, that's very, very, very important. Okay. So those are your power of attorneys, a financial power of attorney and the medical power of attorney. As I said, those to me are the most important documents you could have. So once we've got these power of attorneys, you know, what will the nursing home cost? And that's where I was talking about, you know, Sam could lose everything. You know, in this area, you know, it's well over $12,000 a month. The average stay in a nursing home is 5 years. So 5 years times 12 months is 60 months at $12,000 is a total cost of $720,000. Now, if we look back, what did Sam have? Sam and Beth had, you know, assets of $500,000. So if Beth stays in the nursing home for 5 years, it's going to wipe Sam out. Now, what happens if Sam's 72, 73? His life expectancy might be in his late 80s or 90s. You know, how is he going to live? You know, because maybe they have Social Security and some pensions or something like this. But, you know, if Beth passes away, Sam loses her Social Security. Will Sam be able to live? What we're seeing with is a lot of people coming into our office now, especially in the late 80s, 90s, and their health is declining. But they're not sick enough to go to a nursing home, and they can't afford to go to an assisted living, because an assisted living is going to cost $5,000, $6,000, $7,000. But it's not being a safe environment for them to stay at home. So how are they going to pay for their care? And that's what they were saying, because the government doesn't give you any support. The only support that you get from the government is if you're in the nursing home. So is there any way for Sam to protect his assets? So does Sam have to pay privately for the nursing home after Medicare finishes paying? There is a way. It's called Medicaid. Medicaid is different from Medicare. Medicare is basically for nursing home rehab, and that's where I was talking about. You get the first 20 days, then you get co-pays with the first 100 days. But after that, you're on private pay. However, to get Medicaid, if Beth was wasn't married to Sam, if she has any assets, if she had those $500,000 worth of assets, she would spend all of those assets down, paying privately, until her assets were below $2,500. So imagine that you've spent all your life saving your money for the rainy day, and the rainy day comes when you're in the nursing home and all of that money has to get spent down below $2,500. What legacy are you going to leave to your children or your grandchildren? It's a little bit different with Sam. A lot of his assets would have to be spent down, because basically with the $500,000, the $500,000 is divided by 2. So Sam gets 250,000 and Beth gets 250,000. However, the state and the nursing home come to Sam and say, whoa, Sam, you've got too much money. You're not allowed to keep that 250,000. You're allowed to keep 120,000. And so Sam's balance from the 250 and the 120 goes over to Beth. So Beth now has $380,000. And that $380,000 has to be spent down below $2,500. Okay. Now, so that's how you qualify for Medicaid. One is you've got to be sick. You can't do it at least 2 to 3 activities of daily living. You need skilled care. You've got to be in the nursing home, and your assets have to be below $2,500. You will then qualify. But what happens if, when you apply for Medicaid, the government, Medicaid people go back 5 years to see what you've done with your money. Now, it's okay if you're spending money on yourself, that's okay. But what happens if your children needed some money with credit card debt? They were going to go into foreclosure or bankruptcy. You give them money. What happens if your grandchild needs money for a wedding? What happens if you just, give some money for college education? Or you've been, whether it's Christmas, Kwanzaa, all these types of Easter, you give them money. Medicaid looks at that as that you're trying to defraud Medicaid because you're gifting money away instead of being able to give this money to the nursing home. You're trying to defraud Medicaid. So basically, for every $10,000 that you gift away, creates 1 month of ineligibility. So what do I mean by that? So let's, over the last five years, you've given $100,000 away to your children, your grandchildren, for various activities, as we mentioned, for education, birthday gifts, Christmas gifts, weddings, college education. So what happens is that $100,000 is divided by approximately $10,000, and that is 10. And that creates an ineligibility period of 10 months. So what happens if I was a single person, or Beth is a single person? She now qualifies for Medicaid because she's in the nursing home, she's sick, and her assets are now below $2,500. Well, what happens is then Beth wouldn't get Medicaid, or I wouldn't get Medicaid for 10 months. Because we gave away that $100,000. So how is Beth going to pay the nursing home at $15,000, and all she has is $2,000 in pension and Social Security? So the big problem is, then who signed the nursing home contract? It just so happened that their son signed the nursing home contract, and when he went through the nursing home contract, they were just saying sign here, sign here, sign here, initial here, sign here, because the contract is like 30, 40 pages. And lo and behold, to his son, he is now a responsible party for paying for Beth's care for the next 10 months, because he signed as a guarantor, meaning if Beth couldn't pay, he has to pay. So all of a sudden, for the next 10 months, Beth's son, it has to fork out $120,000. Remember, we're talking about power of attorneys, how very important they are. Well, if Beth's son had signed as a power of attorney, he would not be responsible for the nursing home care. But because he signed it as an individual, and he signed it as a guarantor, he is responsible. So you've got to be very careful about who signs the nursing home contract in making gifts during the look back period. Now, is there ways to protect your assets instead of giving it all to the nursing homes? Absolutely, and that's probably why you're here. So you'll need our help to navigate the process. Okay, I'm sorry, I skipped a couple of slides there. I'm sorry. So what we're going to do is about asset protection. We're going to talk that a little bit in a couple of slides. But what happens if Beth dies? So she passes away. What's going to happen? Well, what happens if Beth dies and she has any assets in her name only? Then we have to go through the probate court. And probate is a whole process that you've got to go through the court, and it usually takes about 12 months. Takes a lot of court costs and attorney's fees. And basically that's where you have the will, and you have the will drives the person's best estate through the probate. Most people think, well, I have a will, I don't need to go through probate. Well, if you have a will, you end up going to probate. So if Beth has a checking account, a house, a car, a savings account, just solely in her name, all of those assets would have to go through this probate process. And then it takes about a year because you've got to go through inventories, accountings, courts approvals, and then the monies would be distributed to whoever Beth has in the will. Usually it would be Sam, and if God forbid something happened to Sam, then it might go, to the children or grandchildren, charities, whoever you want to do. So that's an issue. Now, if the house is in joint names between Sam and Beth, if they have checking accounts between Sam and Beth or jointly, or you have IRAs or 401ks with named beneficiaries, that money would go either to the surviving joint account owner or the named beneficiaries. Those monies would not have to go through probate. It's only any items that is basically in Beth's name only, then that would have to go through probate. And obviously, if there's any federal and state taxes, those would need to be paid. Now, for Beth and Sam, they do not have to worry about federal and estate tax because federal estate tax is if Beth and Sam had more than $22 million, the federal government would come knocking on their door, but they only have like $500,000, so the feds are not interested. Neither is the state of Maryland, okay, because you've got to be well over $5 million for the state of Maryland as well. So federal and state taxes do not have to be paid under Beth and Sam's monies, okay? So is there a better way, regarding probate and how to protect your assets? Yes, there is. And here's how we can help you. Plan for your future, protect your assets to ensure your quality of life. So what we do is we develop a wealth preservation strategy to protect all of your assets. And basically, we're looking at it into like two components. One is what we call pre-crisis, and the other one is a crisis, okay? So the pre-crisis is we're looking ahead. What can we do for the future before Beth goes into the nursing home? So let's say Beth and Sam came to our office. We would come up with a strategy, how to protect the assets, and also how to avoid probate. So regarding, how do we protect your assets in our what we call our pre-crisis, one of the things is what we call an irrevocable trust. Okay, most people have heard of living trusts or revocable trusts, and I'll talk about that in a minute. But what's an irrevocable trust? Well, the irrevocable trust is a trust. So for a lot of our clients, we're taking the house and putting the house into this irrevocable trust, and maybe then we're putting some money into this irrevocable trust. And how the irrevocable trust works is it's basically like a will substitute with asset protection. So with a will, as we talked about, Sam and Beth are saying we're leaving monies to each other. If we both die, it's going to go to the children or grandchildren or whoever you name as your beneficiaries, charities, etc. That's the same thing with the trust. So if Sam and Beth both die, that money would flow out of the trust to the named beneficiaries. So what we call Sam and Beth are the owners of the trust. They're called the grantors. If you think of the trust as a little business, I think that's the easiest way, so they're the owners of the business, they're the owners of the trust. And also with a business, you have managers who manage the business, the same thing with the trust. So we have what we call trustees who are the managers of the business. And then with the business, you have shareholders. It's the same thing with the trust. We have named beneficiaries. As we talked about, the named beneficiaries could be the kids. So with this particular trust, and it's different from the revocable trust, and I'll talk about that in a minute, but with the irrevocable trust is that both Sam and Beth can be the owners. However, they cannot, I'm going to stress this, they cannot be the trustees, and technically they're not the beneficiaries either. So once Sam and Beth put monies into this trust, they can't get their hands on it. And if they cannot get their hands on it, neither can the nursing home. So one caveat is you've got to set this trust up and fund the trust with assets 5 years before you're going into the nursing home. Okay? So that's the irrevocable trust. So let's say I put my house and I put $200,000 into this irrevocable trust. I do it today. 6 years from now, I go into the nursing home. That house and that money that I put into the trust is protected. That means the nursing home can't get at it. Okay? So that's where we're talking about our pre-crisis strategy. We're going to come up with a plan. Wealth preservation strategy to protect your assets in what we call our pre-crisis plan. The other issue is what we call a crisis plan. So we're in crisis, like Beth and Sam. They're in a crisis mode. They haven't done anything. They haven't done power of attorneys. They didn't have wills. They don't have irrevocable trusts. They haven't come up with a strategy. They're in a crisis. Beth is now in the nursing home. Now, a lot of people will say, well, we didn't do anything prior to the 5 years, so there's nothing that we can do. Well, Beth is in the nursing home. Now there's nothing that we can do. That's baloney, okay? So even though that Beth is in the nursing home right at this moment in time, Sam can protect 100% of those monies, okay? Remember, we were talking about Sam could only keep $120,000, and then Beth had the $380,000, and Beth's $380,000 had to get spent down below $2,500. Well, there is ways to take that $380,000 and transfer it over to Sam. So now Sam has his 120 plus his 380, so he's got the $500,000. And Beth has no money. So now Beth qualifies for Medicaid because she's sick, she's in the nursing home, and she has below $2,500. So that's how we can come up, we come up with strategies to move those assets from Beth back to Sam. And so now we can get Beth on Medicaid. Then Medicaid pays for the nursing home and medical costs, etc. And we're protecting the assets for Sam because he needs that money for the rest of his life. So we have the pre-crisis, setting up some sort of strategy that might be some sort of irrevocable trust. And we'll also have the crisis. And the crisis is, how can we protect your assets if someone's going into the nursing home or already in the nursing home? Okay, so that's how we come up with a wealth preservation strategy, depending on where you are. But then let's go back to, the probate. Remember, we were talking about the probate. If Beth had died, and then, she's got assets in her name, or even if something happened to Beth and everything transferred to Sam, then Sam died, but everything's in his name. He's got the house, the checking, the savings, the cars, the house, etc. Then all of that has to go through probate, and that all gets tied up for 12 months plus. And then, it costs attorney's fees, court costs, probate fees, etc. So then how do we avoid that? One of the ways to avoid that is it's like what we call a revocable trust. It's different from the irrevocable trust. It's called a revocable trust. Now, the big difference is, once again, this is a will substitute. And the reason it's a will substitute, because once again, the revocable trust is you're naming your beneficiaries, and that money will go out to the beneficiaries once you die. So once again, Sam and Beth are the owners, the grantors. So they're setting up the named beneficiaries, who the successor trustees are. The big difference with the irrevocable trust and the revocable trust. So in the irrevocable trust, Sam and Beth can't be the trustees or the beneficiaries. Now with the revocable trust, Sam and Beth can be the trustees and also the beneficiaries, as long as they're both living. Okay? So it's called a revocable trust because they can make changes to it. The irrevocable trust, they can't get into it, they can't make changes, hence the word irrevocable. But with the revocable, they can make changes. That's why it does not protect your assets from the nursing home. Can't tell you how many people come into our office and say, my assets are protected from the nursing home because I've got a revocable trust. And I have to tell them, no, the revocable trust does not, let me stress, does not protect your assets. All it does is avoid probate. The reason why it avoids probate is when you die, the trust owns everything. So when you die, you don't own anything, although you own the trust. The trust is your house, monies, whatever. So there's nothing to probate because the trust owns everything. And then that money can go out to your beneficiaries. Or what can actually happen, it depends who your beneficiaries are. Sometimes our clients have problems with, children with alcohol, opioids, all those types of problems. Sometimes they're spendthrifts. And if we were to give them all of that money, if we were to give Bobby $200,000, that could disappear over the weekend, and maybe Bobby would do. So what sometimes is, we call it controlling from the grave. So what you can do is say, hey, Bobby, we're going to give you the $200,000, but we're going to spread it. We're going to give you $1,000 a month over the next 200 months, whatever that is in years. Okay, so we can drip that. Now, once that $200,000 is gone, the end of the trust. But that's how, depending on your strategies, because, once again, when we talk about wealth preservation strategy, you just don't want to give a kid a whole bunch of money. If there's a problem with drugs or alcohol, or even if you were leaving it to your grandchildren. So you don't want to give, $200,000 to an 18-year-old, because how many cars, are they going to ruin, round out? So you might say, okay, we're giving you, Johnny, we're giving you 200,000, but you'll get 100,000 at 30 and 100,000 at 40. Hopefully by that time you've matured. But if you do need money, for health, education, or maintenance before then your trustee can take that money out and give it to you. So that's how we avoid probate. And we talked about how to avoid the guardianship. And avoiding the guardianship is having your power of attorneys that we've discussed in detail. Okay? So that's the big issues, we're going to, come up with a wealth preservation strategy. How can we protect your assets? Are we going to set up irrevocable trust to protect your assets from the nursing home? Are you going to be in a crisis? What other strategies do we have to protect the assets from the nursing home? And how are we going to avoid probate? So what we find is this is your call to action. So ask yourself these questions, could you run out of money before you die? Unfortunately, we're seeing this more and more, because it used to be many 20, 30 years ago that in the late 60s, 70s, 80s, or whatever, most people were dying in, the late 70s or early 70s. And so we had some monies, we had the house, and now, we had our social securities or pensions. Most people don't have pensions anymore. Now social security. Now, if Sam was making $1,500 and Beth was making $1,500, well, that's $3,000. So you can live on that. But if, as we say, if Beth passed away, Sam only gets $1,500. So now $1,500 is not going to get you very far these days. So what happens when he's in his 80s, 90s, or whatever? What happens if he spends all his money on the nursing home? What happens if you're diagnosed with a disease that could last for many years, such as Alzheimer's? Are you protected? Do you have sufficient funds? Because, home care is not, unless you have long-term care insurance, home care is funded money out of your pocket. The government doesn't pay for it. And, 24/7 home care is very, very, very expensive. So have we planned? Can we protect these assets? As we were saying, will you have enough money if your spouse dies? We talked about your income. Your income may be cut in half. You may lose your wife's or your husband's social security. What happens if you've got another 20 or 30 years to live? Are your assets protected from the fluctuations of the markets? So the closer you to 100, the less money that you have in the stock market. Now, a lot of times that people say, well, I've got money in mutual funds. Well, mutual funds are in the stock market. So what happens, if we go back to the crisis in 2008, or even 6 months ago, the stock market crashed, 2008 lost 50%. Now, if Sam and Beth have all their money in the stock market, they started off with 500,000, but if the stock market crashes, loses 50%, they're down at 250,000. Now that money will probably end up coming back, but it might take 10 years for it to come back again. Do they have 10 years to wait for that money to come back? Now, can your age and health in place, even if your health declines? Yes, but you've got to plan for it. What we find is, I call it the ostrich effect, that most people just stick their head in the sand because it's not going to happen to me. I'm not going to get sick. I'm not going to go to a nursing home. I'm just going to go to bed one night and move on from this world wherever we're going to go to. But unfortunately, for most of us, that's not the situation. Statistics are, if you're over 65, there's a 50% chance that you're going to be in the nursing home nowadays. So what we want to do is, we want to be able to help you, answer those questions. So what we find is a lot of people get afraid. And if you're afraid, you procrastinate. Don't procrastinate. What I need you to do is, obviously you're on here today, so you're looking for some answers to some of these questions, and we're here to help you. And don't assume it won't happen to you. Maybe it's that maybe because I'm an attorney, I'm a pessimist, but I always feel like I'm a trained pessimist because I've got to think about the worst. What's going to happen to us worse? And if nothing happens to us, then that's great. But unfortunately, my wife calls me such a pessimist. So what you can do is we can make an appointment to see us today. What we're going to do is, based on this, you can give us a call or we can call you. And because you're on here today, you get a free initial consultation. So normally our initial consultations are $250. But because you were here today, we're going to, waive that initial fee. So that's what we're going to do. And thank you so much for listening to me. I don't know how that's, about 40 minutes. And, statistically they say that's the most that we can do with webinars nowadays compared with our, actual real life seminars instead of the virtual. I want to thank you for being here. So what I'm going to do is open it up to questions or comments. And Kristen, was there any questions when we were going through? And if you can open it up. And I was going to just say, when we open it up, it's like, we have these family Zoom meetings and everybody's talking at once. So, and then we all get discombobulated. So just try and be respectful and one at a time. Okay. Thank you.
Yes. Well, hi, this is Kristen, and I did ask the participants to unmute their speakers. I have no questions in the chat room as of this moment, but people are free to unmute the speakers and speak freely. And we see the phone number on the screen that if we don't hear from anybody with questions, you're free to call us, or we will be following up with you in regard to a free consultation if you're interested.
Hi, I just put a question in the chat box. I was wondering if, quote unquote, signing my house over to my children is an option rather than an irrevocable trust, and what would be the pros and cons, I guess.
Okay, that's a great question, Kathy. A lot of people like to do that. I do not like giving my children or other people's children, the deed. So yes, you can transfer the deed over to your children. Now, what happens, like if you need to go into the nursing home within that 5-year period, you've just gifted that house. So if your house is worth $300,000, then they divide that house 300,000 by 10,000, or so that means you won't get Medicaid for at least 30 months. So that's an issue. Another issue is what happens, that if your son or daughter or whomever, what happens if they go into a nursing home? They've just, you've just exposed your property to the nursing home for them. What happens if they have to file for bankruptcy or foreclosure? God forbid that they were in a car accident. Then you've got these personal injury attorneys putting liens on, the house. So if you have to sell that house to pay for your assisted living, they've got to pay off those liens. What happens, if they've got disability and, they have medical expenses, etc., then those liens would go on against the house. So, yeah, the advantage is it's a lot cheaper to, to do a deed to transfer your property to your kids, okay? However, the disadvantage is what we've just talked about. Also, another disadvantage is taxes. So if your kids inherit through the trust or through a will, they get what we call a stepped up basis. And what does that mean? So let's say you bought your house for $200,000 and now it's worth $300,000. And the kids sell it, they have capital gains, and you transfer it to the kids, and then the kids sell it for $300,000. The kids then have capital gains of $100,000 because they have to take your original basis, and the original basis was $200,000, and now they've made a profit, of that $100,000 because they now sell it for $300,000, so they get capital gains on that. Now, if they were to inherit it through a will or the trust, they get what we call a stepped up basis. So their basis is when they inherit it, it moves from the 200,000 to the 300. So if they sell it 300,000, there's no capital gains. So the one advantage is it's relatively cheap just to transfer it over. The big disadvantage is it exposes you, okay? So I don't know if that answered your question.
It did. Thank you very much.
You're very welcome.
Okay, I'm back on. It looks as though we have another question. It was regarding if a home, if the home is put in a will, shouldn't that avoid probate?
No, it does not avoid probate. Wills do not avoid probate. Wills force you through probate. So if I died and I have a house and it's titled in my name only, then that house has to go through the probate process. So the probate process is they have to do inventories, accountings, and then eventually after about 12 months, that house, would be sold and then, distributed to whom I have as named beneficiaries in my will. So the will forces you through probate. That's where we would either put, our recommendation is you're either going to put the house into an irrevocable trust, to protect it from the nursing home, or, but not everybody wants to do that, or put it into a revocable trust. So once again, you own the revocable trust, but the revocable trust owns the home. So when you die, you own nothing. So there's nothing to probate. However, the revocable trust owns the home, and that then that trust would get the money out, or the trust or the property out, to your named beneficiary or beneficiaries, depending on what you want to do. So the answer to your question is, if you put a house, and it goes through the will, it has to go through probate. To avoid it, we put it into a trust. Hopefully that answered your question. I think you're muted, Kristen.
No, I'm sorry. I was trying to click on that. No, I don't see any other questions at the moment. If anybody has some, please feel free to speak, and I will pass this back over.
Okay.
So
I did have a question. Had two questions.
Yeah, that's fine.
The first one was about the house in a will to avoid. The other is, if you, with the earlier question, if you don't put the house signed over to your children, what if you put them on as a joint owner? What's the effect of that?
Well, the joint owner is, then let's say that you want to sell that house because you need the money to go to an assisted living, or you need that money to pay for your care or just life, and your kids say, we're not selling, you're stuck, okay? Or God forbid, one of the, whoever, your kid you put your name on is, in an accident. Once again, then there's going to be liens placed on that property. So if you have to sell that property, and then, because you want to move into an assisted living, or if you just need some money, then you've got to pay off that lien, or you might not be able to get a reverse mortgage or whatever. So once again, and then they don't get the stepped up basis again. Because you're and once again, you're gifting your house to them. And once again, if you end up going into a nursing home, the nursing home can't get at that property. So you have, the potential of having, penalty periods again. So for me, I don't like, gifting the house to the kids, or even putting them as joint owners. Because let's say you've got your daughter, and you put your daughter on the house, and then she gets divorced from your son-in-law, then that can also, cause a whole bunch of issues as well. Okay. So stick with the trust. That's my recommendation. So hopefully I answered your question.
So
I
to
do
make,
have one other question. I'm sorry, I just unmuted.
No, that's okay.
Do
You're fine.
you require what would be the minimum number of or value in assets to make it worth the cost to go into an irrevocable trust?
Yeah, that's what a lot of people say. You know, a lot of people say, well, I'm not a multimillionaire, so, you know, it's not worth it. It's, I would say 95%, you know, 100% of my clients are well under $1 million, well under $1 million. You know, most of my clients have, you know, a house and a few $100,000. So, you know, we're trying to protect those monies or avoid probate with that. So it's not like having, you know, multi-millionaires. You know, if you're a multiple millionaire, and there's other things that you can do. You know, there's these offshore bank accounts that in the Bahamas or wherever that is, but, you know, we don't deal with that. But yeah, it's really just peace of mind and trying to protect your assets, you know. So it's not like, okay, you know, if you don't have, you know, $750,000 or $1 million, it's not recommended. Now, obviously, if you're sitting there, you know, with $5,000, I do not recommend a trust. Okay. Because, you know, why spend your money, you know, if you've only got $5,000, then, you know, just make it a joint account or whatever. So, you know, there is probably a cutoff, you know, but, you know, for most people, you know, if you have a house and you've got some monies, then whether you're going to be doing an irrevocable or revocable trust, that to me, it's more cost effective setting up a trust than going through the time, effort, and costs of probate.
so to schedule the initial consultation, do we do that now or do we call the number later? How do we do that?
Kristen's on this call on the webinar, so you'd probably be answering the questions. So you can call anytime, you know, as I say, we're doing, you know, with COVID, you know, it used to be that you came into the office and we would sit down and meet with you. But with COVID now, you know, we're trying to minimize, you know, all the, you know, points of contact for your protection, also for us. So what we're doing is we can do Zoom calls, or most people are just using the initial consultation over the telephone. So we can certainly do that. And let's say, you know, that you want to go forward with a trust or, you know, wills and power of attorneys, etc. What we're doing now is that we get all the information from you. We'd send you a questionnaire. You complete the questionnaire, send it back. We draft up all of the documents. We're now sending the documents to you. We used to come into the office, go over the documents, etc. But we send them, then we set up calls to go over all the documents, make sure our understanding is your understanding and everything is correct. And if everything's correct, then what we do is we're doing what we call drive-bys. So you say you drive by the office, we come out, make sure, you issue, the documents. And then we take the documents inside, you know, we copy them, give you all the original, make copies, and you know, then you would drive back again and we'll give you all the documents. So life's a little bit more complicated than it used to be, but we're just trying to be respectful of everybody and trying to be safe.
So as a side note, I will be following up with everyone that attended and those who could not attend, whether it's by telephone or email, a reminder that we are offering the consultation and to see if you'd like to get on the calendar.
Thank you.
You're welcome.
Okay, any more questions? Well, if not, thank you so much. hopefully it's been informative for you. And we look forward to hearing from you and maybe working with you in the future.
Okay.
So once again, thank you so much for being on here today, and be safe in these trying times, okay? Thank you.
Thank you.
Thank you.
Thank you.